Good morning and welcome to the Committee of Adjustment hearings for Panel 3. We are a City of Ottawa quasi-judicial tribunal that holds public hearings to consider Planning Act applications, including minor variances to the zoning requirements and consent to several land. Our hearings are now in person at Ben Franklin Place, 101 Centrepoint Drive. We also enable remote participation by video conferencing to our registered speakers. We are live streaming on YouTube and the video will be archived and available for future viewing by the public. My name is Terry Otto. I'll be chairing today's hearings and you can address me by my name or as chair. And with me are my fellow panel members, Martin Vervoort. Jocelyn Chandler is absent today. Beth Henderson and Gary Duncan. The procedure for the hearings will be as follows. Listed on the agenda and appearing on the screen from time to time are the applications we'll hear today. For the sake of efficiency, I may deal with different items in a different order. Panel members have reviewed the planning reports and any written submissions in support or in opposition to each application. Today, we'll hear any oral submissions relating to the applications. As part of the statutory public notification requirements, each applicant was required to post a sign on the property in the question before the hearing. They also had to confirm in writing that they did so, or they'll need to swear an oath or affirm an oath today that they fulfilled the sign posting requirements. Otherwise, we may have to adjourn or postpone the hearing. The panel may ask for a brief presentation of an application followed by questions for the applicant and city planning staff. We will then hear from members of the public who have registered to speak, and we may also have questions for them. Finally, the applicant, who has the burden of proof, will have an opportunity to make final comments and reply. Please address your comments to me as the chair, starting with your name and spelling if necessary. All presentations are limited to 5 minutes. Any exceptions will be at my discretion. At the end of the hearing, the panel may either make an oral present decision or we may reserve our decision, which means it won't be delivered today. In either case, and within 10 days, the Committee of Adjustment will send the official written decision and reasons for it to all the parties, participants, and anyone else who has requested a copy. Does anyone have any questions about the procedure we'll be following today? Seeing none and hearing none, all right, then we have several applications to hear today, but first we need to deal with some preliminary and procedural matters. Are there any declarations of interest from the panel members? Very good. Confirmation of previous hearings. We have 2 sets of minutes, October the 7th and October the 21st. Has anybody got any confirmation that Martin Vervoort and myself and Beth Henderson were away for October the 7th, so it falls on Gary Duncan?
Yes, I would agree to the minutes.
Very good. Thank you very much. Withdrawal or adjournment requests. The committee has not received any requests for adjournment, so therefore there's nothing to deal with. Are there any other requests or questions about the procedure for today's agenda? Yes.
I just want to confirm that we all agree with the minutes of October 21st, just for the record.
Very good.
Thank you.
All right, then turning before the applications that are before us today, we will first deal with some unopposed applications that are straightforward and recommended for quick approval if there are no objections. The first item is item number 2, 3433 Mulholland. The person is D. Rajala. Are there any questions or concerns in regards to this file? Hearing and seeing none, I would ask the committee to approve this application. 3453 Mulholland is approved. Thank you very much. The next item is number 3, 6051 Herbert's Corners, M-FA, S-FA, K-FA, and J. Racine. Are there any questions or concerns in regards to this unopposed application? Seeing and hearing none, panel members. Application number 3, 6051 Herbert's Corners is approved. The next item is item number 4, 860 Field Down, Cancel, sorry. Any questions or concerns in regards to this file? No. Panel members, approval? Very good. Item number 4, 860 Field Down is approved. The next item on the agenda is item number 1, 2338 Summerside, A sewer.
Good morning.
Good morning. Your name, please?
So the name is Arjun Soor with Novatech, and I'm joined by the property owners, Shelley Quinnell, who are in the audience.
Very good, sir. I believe this is a rather straightforward application, but I do believe we have to hear from you in regards to some discrepancies in the items that are requested by the city. Or would you like to make a presentation?
I can make a presentation first, and then I think we'll discuss the discrepancies.
Okay.
If there are any, I wasn't aware of any, so. Maybe we'll start with the discrepancies then, because we can talk about that first.
Yeah, I believe that it's an unopposed application, except there is a comment from an unknown person, so.
Yeah, so what I'll do then is you already have my fulsome submission and I'm prepared to present, but I'll just address those comments directly. And so the comments, comments speak to concerns related to the floodplain. So what this application basically is we have a property that's currently shown in the floodplain overlay as it shows on Geo Ottawa. And that floodplain overlay comes from the RVCA. And the official plan provides us policy that says that where we have a geodetic survey with new topographical information that shows a different floodplain boundary, we can use that floodplain boundary. In order to use that floodplain boundary, we consulted with staff and they said, look, go through a zoning bylaw amendment or get a minor variance application. And so that's where we are today. We're getting a minor variance application to permit the dwelling within the floodplain, but the floodplain that we have is actually different than what Geo Ottawa shows. And that's a floodplain that's been accepted by the RVCA, as evidenced by their issuance of the permit on July 8th, 2025. And that permit has a list of conditions that I think would address a lot of the concerns that are listed in this submission from the neighbor. And so with respect to the first concern related to floodplain, we think that pretty clearly that addresses it. We're not actually in the floodplain, except for a very, very small portion of the deck, and that portion of the deck is 12 square meters, and so that meets the maximum in the zoning bylaw, which is 20 square meters. In terms of drainage, so part of our submission for the building permit would include a lot grading and drainage plan. In fact, that's actually one of the materials that we have included in our cover letter and the presentation itself. And so those drainage issues have already been addressed through the preparation of a drainage plan. And so we think that addresses that concern. And then finally, in terms of previous decisions, obviously committee members are well aware that, you guys deal with the applications as they come before you. All of these neighboring properties on this side of Summerside Drive are in the floodplain overlay. And so they would need to also provide a survey that shows, a different floodplain if they so choose to do so. So this doesn't, set any sort of negative precedent. Anyone who redevelops those properties would have to go through the same procedures that we're going through today. So I hope that kind of answers the discrepancies. And like I said, I'm prepared to present if the committee wishes.
Thank you very much. Planning, any comments?
I have no comments.
Thank you very much. Panel members?
No questions or concerns.
All right, then I guess we'll ask for approval of this or turn down. What's the rest? Approval? Item number 1, 2338 Summerside Drive is approved. Thank you very much.
Thank you.
The next item on the agenda is item number 5. Is this person online?
Yes, Mr. Chair, Krista Libman's online.
Okay, very good.
Hello.
Good morning.
That is a very nerve-wracking few seconds while we wait to come back into the meeting. But here we are. I'm here for application number 5. As you will know, the purpose of Section 50 of the Planning Act is to control the manner in which land can be divided. And you're all also probably familiar with Sydney Troyster's book, The Law of Subdivision Control in Ontario, which is a trusted resource for all, and in which the Director of Titles, the late Director of Titles for Ontario, describes Planning Act problems as embodying the 3 C's of a problem. They're complex, common, and catastrophic. Common in that they arise frequently in all real estate transactions across a variety of sectors. Complex in that they're difficult to recognize and conceptualize with numerous exceptions and exemptions. And catastrophic because the consequences of a violation can be or are devastating, merciless, auto-executing, and inflexible. Thankfully, the Planning Act also creates processes to correct or to move forward from Planning Act errors, including an application for consent. So here we have the consequence of what appears to have been a conveyancing error that's resulted in a merger and title. 2 lots that were separately conveyable for over 60 years are no longer so, as they don't qualify for an exemption to the subdivision control provisions under subsection 53 of the Act, and they were acquired in the same name. This occurred in 2018 and was left unnoticed by all until the applicant sought to sell one of the lots. So the remedy is to seek a consent to sever the 2 lots. We're also seeking minor variances to bring the existing development that was formerly legal non-conforming into conformity with the current zoning. I have a presentation, if we could put that up. And I think we can actually jump to slide 5.
While you're at it, could you just identify yourself, please, Chris, as I
Oh,
don't
apologies.
think you did that at the start.
Krista Libman, solicitor at Soloway Wright.
Thank you very much.
So we have here, you can see with the 2 yellow stars, 7609 and 7617 Fluellen Road. They're surrounded by rural land uses, including agricultural uses, wooded lands, similarly sized residential lots on both sides of Fluellen Road, and a large vehicle recycling business across the street. The character of the surrounding area is one of a mix of uses, including this cluster of low-density residential units that predates the advent of subdivision control and the official plan and zoning in this area. If the applications are approved, no development will result and there will be no increase in density. The parcels will be as they were for 64 years, with development that's been in place just as long, providing affordable housing in the rural area with no perceptible change or undue adverse impact. In fact, it's unique because the committee is usually, when considering minor variances, asked to consider potential impacts of what might arise. Here we know what will happen because it's been going on for 64 years. The merger and title was unknown to all, as will be the severance. Unfortunately, from my perspective, there are no provisions in the Planning Act that govern this type of unique situation. So we're here before you with the same tests and criteria as for all consents. So the question for the consent is whether a plan of subdivision of the land is necessary for proper and orderly development. And for the minor variances, we have the 4 tests, and most importantly, I think that no undue adverse impact will result. So I've identified here just the undersized lots immediately surrounding the proposed parcels. Further down, there are a few more, and then there are quite a number of rural severances that do meet the minimum lot requirements. Next slide, please. So this is just a quick streetscape. We can see 7623, which is next to the subject properties 7617 and 7609, which are the subject properties. And then this type of development continues down Llewellyn Road for a few more lots. Next slide, please. So Section 50, sub 3 of the Planning Act governs consents, and we look back to Section 5124 to a series of items that should be given regard. One of those items is, of course, the official plan, and staff have noted that they do have a concern with the lot size and whether or not it conforms to the official plan and any adjacent plans of subdivision. I would submit to you that the official plan is a wide-ranging document to be read in its whole, and that it does, in fact, recognize that there are areas in the rural countryside, clusters of low-density residential development that predate the plan. So I think this cluster is actually contemplated by the plan, and for that reason, I do think this criteria is met. Next slide, please. So what does the city want to achieve in the rural countryside? They want to protect and enhance the rural character, strengthen the rural economy, and limit the fragmentation of rural lands. It's my position that the rural character of the area is protected. I think we're a slide ahead, actually. One more. Other way. Yeah, there we go. These lots contribute to the rural character, and the approval of this severance will not fragment the land. They're already there, basically. This type of issue has been before the Ontario Land Tribunal, and there it was found in the case that I've cited here that adherence to all official plan policies is very rarely absolute, and conformance is less uniform still in long-established areas which predate the introduction of planning controls. In that instance, the tribunal found in favor of the application, acknowledging the planner's opinion that nothing would change. Next slide, please.
Krista, I think your time's up, but could we just maybe speed things up a little bit here? I believe the planning has has to say something, but it's mainly the conditions that you're concerned with. Is that correct?
Oh, that's what I'm concerned with, but staff had concerns with the consent and the variance. But if the members don't share those concerns, I'm happy to move on to the conditions.
I think we'd like to hear from planning first, if that's okay.
I have no comments, but I'm happy to take any questions you have.
Very good. Back to you, Krista.
Okay, do we want to go straight to the conditions?
Yes, please.
Okay, great. Let's go to slide 15. So staff have recommended 4 conditions. The first 2 I don't object to, but I would be happy if they weren't imposed, of course. The first one is proof of the existing wells and septic. And the second is to enter into an agreement with the city regarding the quality and quantity of groundwater. I guess, again, I see these as sort of conditions for prospective development, which is not what we're dealing with here. But if the committee would like to impose them, I would not object. Number 3 and 4, however, I don't think are necessary in the current circumstances. Number 3 requests a hydrogeological and terrain analysis, and number 4, if required, requests a mineral resource impact assessment report. Both, I think, are prospective. I raised this concern with staff, and they noted that if I asked for these to be removed, they would not object.
And number 5, you're in agreement with?
Could you remind me, number 5?
Relocation of the overhead services in regards to the Ottawa Hydro?
Oh, I hadn't noticed that one, but sure thing.
You're in agreement with that?
Yes.
Okay. And the 6, 7, and 8, the standard conditions?
Yeah, no
okay,
problem.
That's good. Planning, are you willing to remove items 3 and 4 in the conditions?
We're okay to remove those conditions.
Very good. Thank you very much. Any final comments, Krista?
No, I'll just say that it's my opinion that a plan of subdivision is not necessary and the tests of the minor variance have been met.
Very good. Thank you very much. Panel, can we make a decision on this now or?
Yeah, I was just gonna say, I realize the lot is undersized. And typically we request conditions regarding mineral resource impact assessments and hydrogeological reports. But in this case, it's an existing property that's merged. No new development is required. So I'm in favor of the application with the removal of conditions 3 and 4.
Thank you, Mr. Reward.
Thank you, Chair. I'm in favor of the applications with the removals of condition 3 and 4.
Very good. And Gary, you're okay. Very good. I'll call a question, approval of this item. Very good. Thank you very much.
All right. Thank you very much.
Thank you for your attention. Next item on the agenda is number 6. $1261 Stittsville, Maine.
Good morning, everyone. Crystal McConkey for the record, MCCONKEY. I am the lawyer for the Shops of Main Street, the applicants, with respect to 2 long-term lease consents at 1261 Stittsville, Maine.
Thank you very much. Any comments? I believe that there's one disagreement between you and planning in request to the conditions.
Yes, but not so much a disagreement at this point. I was in touch with Ms. Yang, and Ms. Yang agreed that given the circumstances that no actual lot is being created, that a JUMA is not necessary in the circumstances, and she said that she wouldn't object to removing that condition today.
Very good. Thank you, Crystal. Planning?
We have no objection to remove the condition.
Very good. Thank you. So you are in agreement with the standard conditions 2 and 3?
Let me just double check. I have only condition 1 here is 2 and 3, the registration and
Yes, the registered reference plan and the electronic registration.
absolutely no problems with that.
Very good. Thank you very much. Committee, can we ask for approval of this or questions? Yes.
Just a quick question for Ms. McConkey. So I assume any issues regarding maintenance or shared driveways, et cetera, are dealt with in the leases?
Yes, they are. So all of the uses and maintenance of all of the lands is already dealt with within the leases. And
Okay.
the ownership of the parcel remains with the owner of the rest of the lands. And so a joint use agreement for the owners of the lands couldn't be binding anyways.
Yeah, understood. Thank you.
Thank you very much. Can we ask for approval of this submission? Thank you very much. Your request is approved, and that brings us to the end of our day, and thank you
Thank
very
you
much.
so much for your time this morning.
You're more than welcome. Thank you very much.
Thank you.
The meeting is adjourned. Thank you.